without further ado, I give the floor to Justice Debbie Mortimer and to the case of Australia, probably also hearing something on the effectiveness within the legal system. Thank you very much.
All right. Thank you, Jens. I'm going to stand up if that's all right, and everyone can still hear me.
Yeah.
Is that all right? On the microphone, I think.
It's only for the... But
I have to sit? Okay.
No, maybe... Okay, maybe... Okay.
There we are. Okay. Can I start by thanking Roberto and Jens for the invitation? I'm very pleased to be here, and I'm especially pleased to share some experiences from our court with you of the way that we deal with native title claims, which is what I'm going to focus on. Now, I've prepared a PowerPoint that covers a lot of different issues about the way Indigenous people are treated in Australia. I'm not going to have a chance to go through all of them orally with you, but if you would like the PowerPoint, you're very welcome to have it. So I'm going to flip through some slides quickly. I'm going to focus on three things. I'm going to focus on something that Alexandra touched on in the criminal justice system about circle sentencing and Indigenous courts. I'm going to then say also a little bit about language, Indigenous languages and interpreters in the judicial process, and spend most of my time telling you about the way our court's native title jurisdiction is exercised and showing you some photos of what it really looks like when we're exercising that jurisdiction. But I need to start with some introductions for you. Now this is a map very commonly found in Australian law schools and courts and other places that deal with Indigenous people of Aboriginal Australia. I put it up for a number of reasons. Firstly, see how big the place is. So when we are dealing with issues about Indigenous people, we are dealing with geographic challenges. We are dealing with people in very remote areas, people in regional areas, people in the cities. Some of those people live still very traditional lives. Some of them do not live traditional lives at all. Indigenous people in Australia have, like many Indigenous people, a history of dispossession and removal. So a lot of them have lost their connections with their cultures. So when we talk about how we address Indigenous issues, they are not a homogeneous group of people. And I think that's very important to remember. This map shows you one of the big differences, for example, between Australia and New Zealand. You can see the number of different nations or clans or groups that we are dealing with when we're looking at Indigenous connection to land, Indigenous customs. Indigenous languages, there are hundreds. Some are much more well preserved than others. But when we're talking, for example, about how we incorporate Indigenous language into general Australian community life, we are not dealing with a single language. And those sorts of things provide very large logistic problems for incorporation. And I think it's worth remembering that. I'll go now to this issue about Indigenous identity, because as I talk to you about Aboriginal people, who am I talking about? This issue about how the law in Australia treats Aboriginal identity. You see in this quote, there are really three elements. There is the element of descent, there is the element of self-identification, and there is the element of recognition in the Aboriginal community. And generally, Australian law requires those three things to be present. Now, within Indigenous communities, there's some criticism about the descent issue, the genetic issue. And this is a quote from our Aboriginal and Torres Strait Islander Social Justice Commissioner saying that very thing, criticising the focus on can you prove your descent to prove your Aboriginality. Now, you have that criticism on the one hand from some Indigenous people, but interestingly, what we find in native title cases, when we are trying to trace who is entitled to ownership of particular parts of land, under customary law, Indigenous people will often tell us it's descent-based. So when we're dealing with land, and of course then we're dealing with the most powerful resource for Indigenous people to have access to, often the Indigenous evidence will be, no, it's descent-based. And if these people, this group, can't prove their family, their genetic connection with us, they're not part of us. So you have this tension within the way that Indigenous people approach these issues, and that's I think, it's a justified tension, because these are people that are dealing with a lot of issues about removal from their families. So if you look only at descent, you ignore the history of dispossession, which is unsatisfactory. I want to say something also in the introduction about our judiciary, just to explain the scene for you. I've set out on the slide there, you know, we have a federal system, so we have state judges, federal judges. That last dot point will help explain the next statistic. So like many common law countries, judges are generally drawn from the ranks of the legal profession. Generally, you have to have worked, usually as a barrister, for a long time before you get a senior judicial appointment. And then you can see this. In Australia, as far as I can see from the statistics, we have only ever had 5 Indigenous judges. We have 2 across the whole country at the moment, and we have none in our superior courts. So here are some numbers. So in my state, the state of Victoria, 601 judges and magistrates, 1 Indigenous judge. That is the only Indigenous magistrate across the whole country. At federal level, 165 judges, 1 federal circuit court judge is Indigenous. So we have a long way to go before we come anywhere near representation. But if you look at the statistics for the legal profession, they are also bad. They are not this bad, but they are also very bad. So until generally there are more Indigenous people in the legal profession, these statistics are not going to improve. There are a whole lot of ways in which Indigenous people are represented in our legal system. I can't go through them all. That third dot point, heritage protection, that's a very interesting area. It's not one I'm unfortunately going to touch on today, but there is a lot of legislation about heritage protection. Sometimes it's effective, sometimes it is not. The Office of the Federal Aboriginal and Torres Strait Islander Social Justice Commissioner under the Australian Human Rights Commission Act, that is an extremely important policy office for the development of Indigenous issues in Australia. If you ask who leads the debate and the proposals for reform and initiatives on Indigenous issues, to my mind, it's the Social Justice Commissioner. And you'll see that in their reports and in the initiatives that they take. It's the Human Rights Commission and this Commissioner who is leading the work on the declaration that Alexandra talked about. It's not coming from government, it's coming from the Human Rights Commission. I gave you a reference there in that second dot point to a very recent High Court case, which is, I think, an interesting reflection on how far Australian domestic law has got to go about these issues. That's a case about race discrimination and state control of Aboriginal communities. It failed, and there's a lot of discussion in that case about the irrelevance of international law, not the relevance of it. And it's a good snapshot of, I think, how far Australian courts have got to go in those issues. I'm going to slip over some of these. Now, this is the depressing part of the presentation, but it's important, I think, to understand context here. One of the points I'm going to make at the conclusion is I don't see how legal reform will be effective without reform of disadvantage. You know, Aboriginal communities are incredibly disadvantaged. Look at these statistics. Look at the first dot point. 14 or 15 times the rate of incarceration. Look at the last dot point. Indigenous women 31 more times likely to be hospitalised and 10 times more likely to die. So education, you know, the statistics are still very bad, and that first dot point gives you an example of what I said at the start, the difference between remote Australia, Indigenous people in remote Australia, and Indigenous people in the city areas. You know, there are very great disparities. that government needs to deal with in terms of resource allocation. Health, these statistics are still really bad. Look at those last 2 dot points. So you are dealing with communities that are very disadvantaged on very basic issues. So then when you start to talk about how you're going to incorporate them into your justice system, how you're going to get them appointed as lawyers, we are still dealing with issues of disadvantage at a much more basic level than that. The declaration, I really don't have time to say too much about it. Let me emphasise this. One of the themes you see in the declaration is the issue about consultation and autonomy, and one of the strong comments coming from our current Social Justice Commissioner is the lack of respectful engagement by government with Indigenous people. So that is what he is highlighting. He is saying, you are not seriously engaging with us in the way the declaration requires. You are simply telling us what you're going to do after you've decided to do it. And that is, I think, a very strong feature of the current political and legal debates, legal changes as well in Australia. It's is this issue about lack of consultation. The last dot point is also, I think, important. Maybe it answers a little bit what John was asking about, how does this work in a domestic situation? Commissioner Gooda has said what is lacking in Australia, now that Australia has committed to the declaration, is any strategy of implementation. There's nothing. There's some statements, but there's no strategy. And certainly this Commissioner sees the strength of the declaration as providing a framework for a strategy moving forward, a reference point. But that's what he is complaining is missing from the government's attitude at the moment. One of the initiatives that the Commission, the Human Rights Commission, has taken, again talking about how does this translate in domestic situations, is the Commission has gone around Australia to remote and regional communities and communities in the cities, talking to Indigenous people about the declaration, about what it means to them and how they might use it. And I really like that quote at the bottom about self-determination can be described as a car, that the government has taken the keys, but that doesn't mean they own the car, and Indigenous people just need to get the keys back. And so you have some grassroots education about the declaration and its importance, but who is doing that work? The Human Rights Commission is doing that work. And again, it's not, in that sense, being driven by government at all. Now, this is an aspect of, I'm now jumping to the criminal justice system and the way that we see customary law in the criminal justice system. But because I want to move on to the things I want to focus on, I'm not going to stop. If you're interested in this, I have some stuff in the PowerPoint about it. It's a very interesting issue about how you accommodate what is, if you read that quote, it's a very confronting act, payback, under Indigenous customary law. And the way that ought to be accommodated in sentencing when you have a person convicted of murder, you know that they're going to be subject to payback in their own community, they're going to be speared, is the court can't condone that how does the court condone that? By taking it into account. And yet, judges are trying to balance these things because even though Australian law disapproves of that payback will happen and that person will be punished in that way. So the court can't shut its eyes to those things. And there are very interesting discussions in these cases about how you tread that line between accepting what you know is going to happen to this Aboriginal person, but not condoning it. This case is an interesting example, not a spearing case, but a case where there was payback within the community for a woman who had assaulted her husband, and the quote is from the victim. So the husband was the victim. And it's interesting to look at what he says. You know, he says, under our law, everything is settled because there has been payback. And so why doesn't Balanda law, that's one Aboriginal word for white Australian law, why doesn't Balanda law respect that? And he says, you know, the system has decided, and your law says no double punishment, but what you are inflicting now is double punishment from our perspective. And so you can see that in this case, the judge accepted that as a powerful statement. And on appeal, the judge imposed no further punishment on this woman. So sometimes you see the judges at an individual level accepting the reality of customary law, but it's discretionary, very much dependent on the judge. But this notion of restoring peace to the community as a whole, because the dispute had been settled under customary law, that was something this judge accepted. Customary marriage is another issue, and I'm going to pass over this only to say, though, that this is a big problem in criminal cases with male defendants and female victims, where defence lawyers use customary law as part of their defence strategy. In this case, the statutory rape of a 15-year-old girl, and the defence lawyer said that there was a customary marriage, and that ought to be taken into account. There's a variety of reactions from judges about that. Some judges, you will see the second dot point, will say, I'm not going to take that into account because then you have an uneven standard between Indigenous victims and non-Indigenous victims. Other judges say, well, if that is the law and custom, you know, how far do we respect those things? This is what we were discussing in the previous session. And it's still very, you do not have a uniform approach, I think it's fair to say. This is a very recent case where, one of a number of cases where there's an attempt to introduce into Australian law the approach you have in Canada about, in sentencing, looking at Aboriginal disadvantage. It's not very successful. The High Court has said, no, really, we don't agree with that approach because we see it as reducing individualised justice. Justice is individual. You don't stereotype a person by saying they're part of an Aboriginal community and therefore they're disadvantaged. You look at the effect of the disadvantage on the individual. So that line of argument is currently not being very successful in Australia. Okay, alternative sentencing processes. This is a success story, I think, one of the success stories in the criminal justice system in Australia, not uniform yet across the country, but in various states. You can see it's called various things. It works at a couple of levels. I'll tell you in a moment. It's only working for people that plead guilty, and only to specific kinds of offences, generally lower offences, not for murder, not for sexual offences. In fact, I think not for homicide, not for sexual offences, but for a range of offences. So it captures a lot of offenders, but not the very serious ones. And the idea is that you include in the sentencing process people from the offender's Indigenous community, and that you change the physical circumstances of the court so as to make them less intimidating for the individual. So you don't have the judge sitting up on the bench. The judge comes and sits at the table. Around the table are all the people who are concerned with the punishment and rehabilitation of the offender. So the offender's family, officers, Indigenous liaison officers, everybody is sitting around a table. You have judges who are trained specifically in cultural issues who do this work. You have, especially important in this process, you have Aboriginal elders or respected people in the Aboriginal community. Now, they are not volunteers anymore. When this started, they were volunteers. Now they are paid and they are recognised as having a very official role, which they tell us is very important. And they talk directly to the offender about what impact the offender's behaviour has had on the Aboriginal community, on their community and on their family. And there's quite an aspect of shaming, which is an important issue in Aboriginal culture. And so they have that role, but they don't have a role in sentencing. So you have this discussion, you have the offender is spoken to by these people, the impact is discussed, but then the system changes and the judge goes back on the bench for the formal sentencing process. So you have this integration where for a while the process is more sympathetic to Indigenous approaches, but the formal sentencing, same principles as non-Indigenous people, and the formal sentencing in terms of the way the court is set up, same principles. I think this quotation is really interesting from an offender. He says, well, in the Koori court you feel like the size of an ant. And when they talk to you, he's talking about the elders that are around the table, you start getting a lump in your throat. So this is a very live description from an offender of what it's like to be spoken to by the people in your community who are your elders and who you respect. And the statistics are that it's a very successful program. There are criticisms. This is a very good article about the evaluation of the system. And what the author says is that there's still a tension about are you simply taking parts of Indigenous custom and transposing them into the dominant legal system, and the parts you don't like you leave alone. And so she questions, how much of an entire attempt it is to incorporate customary law. But nevertheless, her article concludes that on balance it's a very successful initiative. It's not available in every state in Australia. These are not federal-driven processes, these are state-driven processes. So again, you have a lot of unevenness about it. If you're an offender in Victoria, an Indigenous offender in my state in Victoria, there's a lot of these programs. If you're an Indigenous offender in Western Australia, and there are more Aboriginal people in Western Australia, you don't have such good access to these programs. So it's very uneven. Okay, language and interpreters. There are two issues I want to touch on, access and content. So in Australia, they're dealing with a lot of different Indigenous languages, and access is a real problem. If you go out into remote Australia, as I've done both as a barrister and a judge, the reality is it's very difficult to get interpreters. You can't use them on the phone because there's no phones. You can't use mobile phones because there's no mobile phone coverage. So in a city, it's all very well to say, if you can't have an interpreter present, you can get them on the phone. What do you do when you have no phones? Behind that, you have the problem that there are not enough Indigenous interpreters because the education levels for a lot of Indigenous people who still have their language are so low that they can't qualify as interpreters. So you have all these problems beyond the right of access, the practicalities of it, very difficult. There was this very interesting survey done in the Northern Territory where they took a group of offenders who had been dealt with in English because it had been decided by the courts and their lawyers that they were capable of having their trials and dealt with in English. But when they were surveyed, over 95% of them did not understand the common criminal terms that had been used in their trials. So these were often people who had pleaded guilty. The whole thing in English, but they didn't understand what bail was. They didn't understand if they had given an undertaking to the court, they didn't know what that meant. So although on the surface they appear as if they are understanding, in fact, they are not understanding anything at all. I'm going to skip over this, just go to a second issue about content. This is a very interesting example, I think. This is from a paper by a linguist about Aboriginal English. This is in a coronial inquest, but what it shows is it's all about what do you mean when you say a half moon? And in English, we have a very clear concept in our culture of what that means. It means when the moon is at half. In Aboriginal culture, half means anything between nothing and half. But here is a person who was giving an account that was nearly disbelieved. So he was nearly found to be an unreliable and dishonest witness, because when he says half moon, the judge looks at his diary and says it wasn't half moon. So you have this complete disconnection between what the witness is talking about and what the European judge is understanding. And again, this is a proceeding in English with none of that cultural awareness occurring until it is pointed out by the interpreter. So, and these things are very common in criminal trials. That, again, and lawyers have a lot of responsibility for this, because language is our method of determining truth when we cross-examine. Our language is very important. We try and close witnesses down, try and make them precise. If they don't understand the concepts, the whole process is brought into disrepute. Okay, let's go to land rights. So real land rights in Australia is a very recent thing, 1992. And it was only after the decision of the High Court in Mabo in 1992 that the Australian government at a federal level was forced to confront the reality of Indigenous ownership of land. That led to the Native Title Act. And this means that when my court deals with native title cases, we are dealing with a lot of evidence about the content of traditional law and custom. And we are asked to decide what that content is and to give legal effect to it. So this is the most prominent example in the Australian legal system of how traditional law and custom is incorporated. So the claims are made, it's only the federal court that deals with these claims, and they are made, the applicants must identify the kinds of rights they say they have in an area, whether they say they have a right to possess it. A lot of these claims depend on maps, very complicated maps, trying to draw boundaries. Again, not really suitable for Indigenous concepts about land ownership. Often Indigenous people work out their country by geographical boundaries, not by a line on a map. But in order to fit their claims into the Australian legal system, lines on maps must be drawn. And so that is the way that the claims proceed. The Native Title Act can give very strong ownership rights. In some circumstances, it can give rights to compensation, rights to negotiate with other landholders. It can be a powerful thing, but it all depends on the proof of the continued existence of traditional law and custom in connection with the land. So some of the practices that our court engages in, which I think are innovative and very important recognitions of the way that traditional law and custom has to be proven. The first is that we take evidence on country. So, for example, in July, I'm going to Western Australia for 2 weeks, way out in a remote area of Western Australia, to listen to Indigenous people give evidence about their connection to that part of the land for 2 weeks. It's a big logistics exercise for a court to go on country like that. We have to take transcript people, we have to take a whole lot of people, but the court makes a very big effort because the difference, I can tell you, between having an Indigenous person giving evidence in a European court, in a city, and listening to them standing on their country talking about their land, it's tremendously different. You see them in a witness box in a court, they're closed, they answer with one word, 2 words, they're so nervous, it's terrible. You put them on their country and you ask them to explain a custom or a tradition, and they come alive. The shyest person in a court, you put business and you have women's business. When that happens, it presents a difficulty for the judge. For example, a woman judge listening to men's business. How is that to happen? And so the court has to develop flexible ways of accommodating the customary restriction and getting the evidence. Because I can tell you what happens is if the court does not accommodate it, then the male witnesses just say, I'm not telling you. I'm not saying anything. And of course, if they don't say, they can't prove what they need to prove their connection to the land. So you have this tension. So our court has developed, I'll give you a couple of examples. In a case a female colleague of mine did, she went, she was on country, in a remote area. She went physically out of sight, and there was a microphone. So the men could not see her, and they accepted that. They said, then we are not telling our story in front of a woman. But the judge was sitting out of sight and was listening, and they were happy with that. I have to move on. So I wanted to show you some photos of what it looks like, and 2 maps. So this is a map of the areas in green that have been determined exclusively to be held on native title. You can see it's very small, apart from a very big area in Western Australia. That represents areas where Indigenous people have occupied the land continuously and have kept strong traditions. You can see on the eastern seaboard, where all the cities are, nothing. You get a better picture of non-exclusive possession rights that have been given across more of the country. But still, so that's a lesser right in relation to those places. Now, I just wanted to show you a couple of pictures here from some determinations I've done in the country. So you see, we judges participate in customary traditions when we go to give determinations on country. That's me walking around in a smoking ceremony before the court session starts. This is we set up a courtroom with a marquee like this. This is quite, you can see the lawyers are robed still. So we have this contrast between the court processes and what the Indigenous community... The little boy, he was to use the clapsticks, because in court, when a judge comes into court in Australia, you knock, 1, 2, 3, and the door opens. So here, he's going to use the clapsticks, 1, 2, 3, before I walk onto the bench. So we try and merge some of the formal processes with the informal processes. This was quite a formal court process for a remote location. This one, you can see, much less formal. So this was, a tent and a table. And I sit there with an interpreter and an Indigenous woman translating, a linguist and an Indigenous woman translating, because nobody that I was talking to at this determination spoke any English. This was the culmination of the native title grant. So everybody gets a copy. All the claimants get a copy of the court's determination. And, they're very proud about that. So it's a very big day for them. But what lies behind it might not, in fact, legally be as significant for them. But what is significant, in my experience, for all Indigenous people that I've dealt with through this process is the recognition The fact that a judge comes in their robes and says to them that Australian law recognises that you have owned this land continually, that's a very important thing, and that's a big development for Australian law. Okay, now I think Jens wants me to stop. Yeah. No, of course. So I haven't been. This is something I haven't been able to talk about, but perhaps at another stage, perhaps Cheryl might mention something about this tomorrow. Yeah, yeah. So to summarise, I think the thing that Australia has done best is its incorporation of customary law into land rights issues. The thing that it has done worst is really the way that it is still, there's such a big gap on all measures of a disadvantage between Indigenous people and non-Indigenous people, that talking about how you get Indigenous people into the judiciary at the moment, you know, it's fantasy. It's really fantasy until those baseline measures are improved. Thank you very much.
I apologise, but we have to respect also the time difference with New Zealand. You are lucky because you are here with us. Thank you very much. I think this was an excellent integration of what we had before from the theoretical side. Now, also, especially also, thank you very much for sharing the photos and the experience of your visit with us. Just connecting with New Zealand here. Hoping that everything will work out fine. No, of course it does not. Okay. Okay, and then I'm also tempted to comment on the, but I won't do now, on the question of recognition and consultation, which was very much in the forefront of your talk, and I think this was a very important focus. But we will now, as we said, have the second presentation immediately, and then we will discuss together.
Hi.
Okay, thank you for your patience, and if you are ready to start, we are ready to listen.
Hello.
Hello?
Hello.
Hello.
Hi.
Let you see part of the audience in the meantime. Is this okay?
Thank you.
Okay, so if you want to start, please go ahead and...
I will. I will. The internet must be slightly delayed because I'm still listening to the previous presentation. So kia ora, everybody. My name is Claire Charters, and thank you very much for giving me the opportunity to present via Skype to the conference. It's a very interesting conference, and one that I've enjoyed engaging with the topics and the questions that you're looking at. I'd just like to begin by introducing myself into Reo Māori so that you get some sort of sense of who I am. So, ko Rotorua te moana, ko Nongataha te maunga, ko Rotorua te moana, ko Ngāti Whakau te iwi, ko Claire Charters tāku ingoa, tēnā koutou katoa. So in terms of talking about customary law, I guess one of the important parts of Māori culture is who you are and that you belong to a collective. So when you're introducing yourself, as I just did, you first of all name where, well, usually the mountain that you come from, the main body of water where you're from, the area you're from, then you talk about your tribe or your nation, and you refer to who you are. So that, sorry, I've just got some feedback. So that explains then who you are as an individual. I'm just wondering, I can hear some feedback, which is making it a little noisy. I'm just wondering if it's possible to turn off one of the speakers. Thank you. That's great. Fantastic. So one thing that I would like to do in this paper is just talk a little bit about the unitary nature of New Zealand's state, which allows for very little, I guess, accommodation of tikanga Māori, which is how we refer to Māori customary law. Secondly, what I'd like to do is just focus on one particular case where tikanga has come before the mainstream courts. There is very few examples of tikanga being practiced and accepted by the formal legal system in and of its own account, and that's what I'll explain first. So the formal position is that under New Zealand's constitution, there is very little space, basically, for pluralism generally, and specifically for Indigenous autonomy or for the recognition of tikanga Māori customary law. So our government is unitary, not federal. We have what I call a hyper-supreme parliament. We've got a very unfettered parliament. We do not have a written or entrenched constitution, as I'm sure many of you are aware. Parliament cannot be explicitly limited by courts. We do have the Bill of Rights Act, but that is expressly subordinate to inconsistent legislation. So our Bill of Rights Act is subordinate to other legislation. Parliament has, on a number of cases, overturned court decisions that have been favourable to Māori rights. Our courts do not question the legitimacy or the supremacy of New Zealand's Parliament or the authority of Parliament to legislate over the territory of Aotearoa, New Zealand. We also have an extremely controlling executive. This is, and the executive is very controlling of Parliament. This is because the executive consists of the leaders of the party in power in Parliament, and through our system of whipping, essentially those leaders in the executive can whip their party and Parliament into consistent policy making and laws consistent with what the executive would like. We do have the Treaty of Waitangi, which was signed between many Māori leaders, though not all, in 1840, and representatives of the British Crown. I'll talk about that a little bit more in a moment. There is one way in which the common law can accept tikanga Māori into the formal legal system, and that's when certain tests are met, set out in a case called Loseby from the early part of last century. And that case, however, requires that the tikanga Māori or the custom law be consistent with common law values, so it can't be repugnant to common law values. Tikanga Māori can also be recognised through the common law system through the doctrine of Aboriginal title, although we don't have much Aboriginal title jurisprudence in Aotearoa, New Zealand, largely because we've had legislation that has dealt with Māori land since the mid-1800s. As this description suggests, this very unitary nature of government, another thing to mention there is that Parliament is only one house. We do have, I guess there is a potential there for tyranny of the majority. Why does that not happen? There is a commitment, I think, in the general populace, or at least an ideal that New Zealanders hold to, and it's one of equality. I would question that as a, I guess, academic in relation to Indigenous issues, but there is at least a self-perception that equality is important. We also have, importantly, a mixed member proportional electoral system, which has functioned to limit somewhat the power of the executive through some sharing of power. We have the Māori electoral roll, so we essentially have a quota system in our parliament. So 7 seats currently out of 120 are reserved for Māori. New Zealand is also somewhat sensitive to international censure, particularly human rights censure. So that is the basic constitutional position. I know many of you will be aware of it, but those who are not, that is really the framework in which New Zealand finds it difficult to recognise any form of pluralism, but also accept or recognise formally any tikanga Māori under its system. The Māori perspective, and I did empathise with the point previously, or find consistent with New Zealand, with Australia too, is that Māori, and like Aboriginal peoples, Māori don't speak with one voice. Māori have different opinions on things, but there is a general acceptance, I think, or questioning of the authority or the legitimacy of non-Māori government or colonial government in New Zealand that remains. For a long time, the Treaty of Waitangi, the treaty I've just mentioned, was considered to be the basis for Crown and governmental authority and Parliament's authority in Aotearoa, New Zealand. However, that treaty does not actually transfer sovereignty. In fact, the Te Reo Māori version, it's in both in English and Te Reo Māori, the Te Reo Māori version speaks of Māori retention of something called rangatiratanga, which has been translated as independence, sovereignty, self-determination, and speaks, however, of the Crown acquiring what's called kawanatanga, which is loosely translated as governmental powers. Consistent with what we now understand as sort of oral representations made during signings of the treaty was that the understanding was that the treaty was to give some power to the British Crown to exercise some governmental power over settlers who were coming to Aotearoa, New Zealand. So there's a real question there about what is the source of sort of colonial governmental authority or mainstream authority in Aotearoa, New Zealand. Did it come from discovery? This doctrine of discovery was sometimes cited in terms of acquiring authority over the South Island, but it's not a very agreeable doctrine, at least through our eyes today, in terms of describing how sovereignty was transferred. Was it through just proclamations, Crown proclamations of assumptions of power that meant that the sovereignty was ceded? Again, that can be problematic as well, but the treaty is no longer considered as to be the source of this transfer of power. So, yes, you've got this formal situation going where you've got this very unitary government, you've got a very powerful parliament, very little pluralism accommodated, and then you've got the Māori view that there's never been any legitimate or legal transfer of power from Māori to what we understand now as the government today via the British Crown. But that picture, what is going on the ground is a lot more colourful and diverse and complex, I think. So there's a few things to note about Aotearoa, New Zealand. So tikanga and customary law is still practiced by many Māori communities. There's practice on marae, on traditional homelands. It is what regulates a lot of activity, and particularly the private domain in Māori community. However, that happens a lot to a significant extent under the radar. So that is just regulation that occurs that many other New Zealanders are actually unaware actually happens. There is some limited recognition of tikanga, of customary legal values in legislation, such as our Resource Management Act and Fisheries Regulation. We've also, thirdly, another important point, with New Zealand is engaged in the treaty settlement process for a number of decades now. And as a result of that, some Māori tribes have acquired significant economic resources, and they use those economic resources to deliver some sort of what you might see as governmental services, so in the areas of education, health, etc. We have a Waitangi Tribunal which analyses historical and contemporary Crown breaches or allegations of Crown breaches of the treaty to Māori. It has incorporated elements of tikanga into its practice and has recognised tikanga as a source of law. We increasingly have initiatives that are similar to the studies that you've just heard about in relation to Australia in our criminal justice system, where tikanga is being incorporated into sentencing practices. That's quite limited, but it is happening. We have some legislative incorporation of the Treaty of Waitangi, which does function to provide some fetter on executive powers where you've had that legislative incorporation of the Treaty of Waitangi. Māori also have considerable, and this is quite stark contrast, I think, to the Australian situation. We do have considerable political power. We make up approximately 15% of the population. We do have a Māori party. Often the Māori party, at least in recent years, has been very important to forming government, which has provided a level of political clout that many other Indigenous peoples don't have at the mainstream level. I would also say that Māori culture is generally important to New Zealanders' understanding of their own identity. Whether of Māori ancestry or not, there is the sense that Māori culture is something that makes Māori and New Zealand unique and different. There are limits to that, however. So when cultural rights start impinging on other non-Māori rights, there is a limit to this sort of sense of attachment to Māori culture. Whenever there have been initiatives or court cases even that recognise relatively strong Māori rights to lands, territories and resources, has often led to a backlash under the phrase of one law for all, that New Zealand doesn't recognise that there can be any sort of separate legal system or separate rights for other people, so Māori. So that's really as background, because what I would like to do is really make the case that despite there being little formal opportunity for tikanga to influence the law, for there being so little pluralism generally, and also in relation to tikanga Māori, that there have been some important cases more recently that do show some avenues or some openings where tikanga can be more influential in the mainstream system. So I'm not actually talking here about tikanga regulating in Māori areas or in areas that, or over certain matters that are important to Māori. I'm talking about tikanga being received by the mainstream system. So just to make that distinction. So there are a number of cases that I will discuss in the bigger paper, but I would like to focus on one that I think is very interesting, the Takamori decision in this presentation. But just briefly to highlight some of the other cases. In a recent case just at the end of last year, from our Supreme Court, our highest court, it was decided that reception of some British common law in relation to ownership of riverbeds was subject to tikanga, so that because tikanga regulated particular areas or pretty much all of Aotearoa prior to settlers arriving, that tikanga would still apply, and that the reception of common law doctrine would be subject to that tikanga in relation to Māori land. So that's, I think, quite an interesting development. In relation to in the criminal justice area, we had a case a few years ago where it was argued that tikanga Māori should be the legal system that determined the outcome in this criminal case. The court held, both our High Court and Court of Appeal, held that the Crimes Act displaces all tikanga Māori because it's a comprehensive system when it comes to crimes, so that there's no residual role for tikanga. But it did, using particular legislative references, did enable tikanga to be taken into account in sentencing. However, the more serious the crime is, in that particular case involved murder and attempted murder, it was found that the more serious the case, the less opportunity or scope there is to take into account tikanga values. And a really interesting case that has been appealed currently to our Supreme Court and is likely to be heard in the next couple of months. One of the issues that came up was around representation and whether a statutory body, albeit a Māori institution, could represent former customary owners of the land, of a particular piece of land. Now, the statutory body represented individuals who had individualised interests in land, in this land that had been formerly customarily held by groups. Now, the court said that the statutory body could not represent the former, the tribes that were involved, or the former customary owners, because it was a completely separate modern body. What was, I guess, problematic about that case is that the statutory body that had been established is the statutory body that represents the former interests of those customary bodies. So through this sort of quirk of applying mainstream law, it's very difficult for this body to represent these former customary interests. It is not a customary body, that's true, but it is probably the most efficient vehicle to represent these Māori interests. But the court did in that case, however, recognise that a kaumātua, a leader or a senior elder of that tribe could represent the interests of that hapu because that was consistent with the customary law. So there was some opening there, recognition of tikanga. We've had other interesting cases. One is a Bullock case, which our Human Rights Tribunal found that the human right to non-discrimination would prevail over any justification for different treatment based on sex sourced in tikanga. So that goes to some of the issues that were being discussed earlier in relation to Alex's paper on the declaration. The final thing before is just introducing these cases is New Zealand has, and our highest courts have embraced the declaration in ways that I even myself as being an advocate formally of the declaration has surprised me to the extent to which our courts have embraced and referred to the declaration a number of times by our highest court, albeit not in a way that is determinative, but you can see the declaration really influencing New Zealand law. It's very much been taken into account when the Treaty of Waitangi has been interpreted as being a gloss or an instrument that you can use to interpret the Treaty of Waitangi. That's a very interesting development in and of itself. In relation to reception of tikanga, it has come up there, but not in a way that I think recognises autonomy or some of the self-determination rights, or even Article 34 that Alex was talking about. But the case that I want to talk about most fully is this Takamori case. This is the case of a few years ago. Mr. Takamori was from an area called Tūhoe on New Zealand's east coast, a very I guess, an area where you might see them, or a tribe that is still very attached to tikanga and its customary law. Now, Mr. Takamori had moved to Christchurch quite a long way from his traditional area and had lived with his wife, and then subsequently when they'd had children with their children in Christchurch for 20 years before he died. When he died, in accordance with customary law, his family from his traditional area came down to Christchurch and, against the wife's and children's wishes, took his body back to the traditional area and buried him in his traditional area. That's consistent with values about the value of the land, about ideas around whanaungatanga, about keeping the tribe whole, about going back to what we call Mother Earth, or Papatuanuku, which is the name that we refer to as our Mother Earth. So very consistent with customary law values. So, for example, in my own case, I've always understood that I would be buried in my tribal area. With my family, and that's where my tribe has always been buried. But this is very much against the wishes of the wife and the children. So the issue that came before the court and then eventually went up to the Supreme Court, when Ms. Clark brought the case, she claimed that as the executor, this was the wife that as the executor, she was entitled to determine where Mr. Takamori would be buried, and was requesting for his body to be taken out of his tribal area and then be brought down to Christchurch. They argued that there was the Takamori whānau, the family that was from his traditional area, argued that there is no New Zealand law recognising that executor has an exclusive right to dispose or choose where the body is buried, and also that the common law should give effect to tikanga. The majority in our Supreme Court found that the executive basically does have primary decision-making authority in relation to disposal of the body, so the wife, but that the wife would have to take into account tikanga Māori in making the decision as to where the person was buried. Our Chief Justice Elias, came to a slightly different decision, and she said that, well, there's no exclusive right for the executor to determine, and what should happen in cases of dispute about where a person is buried is that the High Court, using its inherent jurisdiction, should hear from all parties, take into account tikanga if that's one of the values to consider, and then make a decision. On the basis of the facts, both the majority and Chief Justice Elias found for the wife, Mrs. Clark, and they referred to factors such as that Mr. Takamori had made a life for himself in Christchurch, living there for over 20 years with his wife and his family. They referred to the lack of relationship between Mr. Takamori's family and his tribal area. They did take into account that the tribal area was important to the family, and they did take into account custom, but ultimately, on balance, they thought that Mrs. Clark and the children, their choice was the one that would take primary, would be primary, and that Mr. Takamori should be buried there. And Chief Justice agreed for similar kind of reasoning. Going through the decision, there's some important points to note about how tikanga was dealt with, or how custom law was dealt with in that case. But before I look at those, discuss those issues, one thing that has been quite interesting and subsequently is that they still haven't managed to remove Mr. Takamori from his tribal area. There was a 60 minutes expose on this. This has been an issue that has attracted public attention over the country, and it's referred to as the body snatching case, so not referred to in very, I guess, tikanga-friendly terms. But they have not been able to remove the body because tribal members have literally sat on the grave with guns and said, while the police have come to try to do it, and said, you can't take it, we will basically shoot you, we would rather, we will die, rather than have this body removed. So we actually have a situation now where you've got a Supreme Court order of a few years ago, and it's not been complied with. So I think that's quite an interesting element to the case. What are the issues there? One of the arguments was that tikanga should regulate this matter, that common law should accept tikanga, if there is provision in the Lowsby decision I referred to earlier for the common law to accept and accommodate and recognise tikanga. However, the court sort of sidestepped that issue. It had been an issue in the lower courts, and said that, well, basically, the Parliament is supreme, and their legislative authority, mainstream law from Parliament and common law does apply in Aotearoa, New Zealand. And instead of trying to give tikanga effect through the common law, we'll just make it a factor that decision makers, the executor or the courts, depending on the Chief Justice's or the majority's decision, it's a factor that they have to consider. But this contrasts very much with the views expressed by scholars such as Moana Jackson and Ani Makaire, some of the more critical Indigenous scholars who really question the legitimacy of the authority of the mainstream law in Aotearoa for the reasons that I discussed earlier. Another point, a second point that I want to highlight is, in this case, you've got courts determining tikanga. And I noted before the discussion about how many Māori judges that there are, and we have very few Māori judges. We currently have 2 on our High Court and none in our higher courts. But so you've got courts determining tikanga, essentially, in these cases. So if they are going to take into account tikanga, if there's a dispute such as this case, and that is problematic, I think, to have our mainstream courts determining tikanga. There was a sensitivity to that, and you see a sensitivity in other cases where tikanga comes up. Judges seem reluctant to try and determine what tikanga is, but that is the upshot of cases like this, is the courts are determining what is tikanga, and people who have got very little expertise in tikanga. Although there has been a movement of late, and recent judicial training of our highest courts has included strong tikanga elements, but it's quite different having perhaps a few seminars on tikanga Māori and being well versed or being a decision maker or authority from a tikanga Māori perspective. Another thing is that these facts, it might not seem like that is how I presented it, but these facts are probably some of the more favourable to tikanga than any that you might get. Tuhoi, as I mentioned, was the name of the tribe or the iwi. They are still very much versed in the tikanga Māori. The tikanga was very clear. It is a very clear custom in Māori that you take your body back to your traditional area. There was no question about whether this was authentic tikanga. It is tikanga that is consistent across many different iwi and tribes, but still it failed. It's hard to think of a case where tikanga might prevail over the interests of, say, the immediate family members. There was a real sensitivity, though, I should add, to tikanga, and Chief Justice Elias especially said, well, if she had seen or there was evidence of a slightly more connection between Mr. Takamori and his tribal area once he'd moved to Christchurch. So even a few more phone calls, I think, was the implication, because they discussed how often he called home and rang his mum, that she might have decided otherwise. But it is hard to think of facts that might be more favourable to tikanga. Another point which you were discussing previously in relation to Alex's paper was this potential for tikanga and human rights to clash. What was very interesting is that, particularly in the Chief Justice Elias's decision, was that she refers quite a lot to the right to culture, the right to dignity, so in support of recognition of custom. My question is, and one that comes up in other cases too, is that if tikanga will be supported by human rights to the extent that, say, the right to culture supports tikanga, but once tikanga starts to obviously and clearly clash with other human rights, that there will be problems to our courts recognising tikanga. You saw that most explicitly in the High Court and Court of Appeal decisions when they were looking to see whether tikanga was repugnant to the common law, and in both the previous decisions. So in the High Court, they said that it was repugnant to the common law, couldn't be recognised because it would result in the collective interest prevailing over the individual's interests. Then the Court of Appeal said, well, we can't go down that route because that means that you'd never recognise any tikanga, because tikanga is really about the collective rather than individuals. But they did say that this tikanga involves that might is right, basically, going to pick up a body against the wishes of others, and that was inconsistent with common law principle and therefore couldn't be recognised. So human rights can be some support to some extent for recognition of tikanga, and you see some evidence of that in the Chief Justice's decision. But I think that support from human rights will run out if tikanga really starts rubbing up against some sort of liberal values. My final point in relation to this decision is that, and it goes back to the point about having people not versed, judges who are not versed in tikanga Māori determining what is tikanga, is that there's a real risk that biases and sort of inherent biases will creep in. So one of the tests in terms of taking into account tikanga or balancing these issues was to look at the closeness of the relationship the deceased has with the traditional iwi or tribe, and or with his immediate nuclear family with children and wife. Now, I wonder when you're assessing closeness that if you are brought up in a culture that prioritises the nuclear family, that there might be an inherent bias, therefore, to the nuclear family. Under tikanga, however, family is understood in a different way. Family is generally a lot bigger, extended family, and the importance of sort of longevity of the tribe is at least as important as any of those relationships that establish in a nuclear family. But it could be very difficult for judges to sort of in an unbiased way give due respect to tikanga when it's clashing with their own understandings of family, so particularly arguably the nuclear family. And I should mention, however, that especially Chief Justice Elias, but to some extent the other judges were very aware of this concern. So that they were very aware of one culture being used to judge another culture. So there was a sensitivity to it But that sensitivity, I wonder whether that can really translate into an unbiased assessment of these the two different values behind the different legal system, or the inherent level of judgment that goes into a decision like this. So I'm not going to go through any of the other cases in any depth, but I just introduced them before. But on the basis of Takamori and also the other cases, I've come to some conclusions about how tikanga is accepted or received by our courts and into our mainstream legal system. So the first is that courts will not question legislative or governmental authority, even though the legal basis for governmental authority can be questioned from a Māori perspective. When was that legal transfer? It's a political fact, but when did that actually happen, and how did that happen as a matter of law, international or colonial law? Second, courts determine the content of tikanga that comes before them. So we saw that in Takamori, that they're making assessment as to the tikanga Māori in relation to taking people back to their traditional homelands when they die and burying them in the land. Third, on decisions thus far, tikanga has not fared very well, in fact, so that it's lost against other values, common law values. Based on Takamori, but especially on this Bullock case, which involved a very much a clash between gender rights and tikanga Māori, human rights, liberal values will prevail when they clash with tikanga, it seems. There is a potential that courts will possibly unintentionally favour non-tikanga values where when you're not versed in tikanga Māori, it's very difficult to assess and give a fair assessment, independent assessment to tikanga when that's not part of your understanding of the legal system. The reception of common law, another point, the reception of common law from England is to some extent dependent on its consistency with tikanga, particularly in relation to Māori land. So the common law will be adapted to accommodate tikanga in some places. Tikanga has been extinguished with respect to criminal law, so our Crimes Act is a complete code when it comes to crimes, and tikanga cannot regulate crimes as regulated under the Crimes Act. Tikanga is of little weight in sentencing in relation to serious crimes such as murder. Another point that I didn't raise before, but comes out in the Mason decision, that's the decision, the murder case, that tikanga, the court said that tikanga may need some rebuilding to be viable as an alternative legal system. That was on the basis of evidence received. Courts seem reluctant to diverge from the one law for all kind of mantra. I mean, and there's a sort of reluctance to apply an alternative legal system in Aotearoa, New Zealand, that some people, Māori, might be sentenced differently, for example, because they are Māori and because they are subject to tikanga Māori. Courts have accepted tikanga Māori with relation to representativity. So, for example, I mentioned the case before where the elder was accepted to be a representative of the customary group of the hapu or the tribe, even though, because that was consistent with tikanga, that an elder is consistent. And then my final, so those are the points about the court decisions. The final point I just want to make, just briefly, is sort of an add-on, I guess, because one of the questions was around the declaration. I mentioned that the Declaration on the Rights of Indigenous Peoples has been received by our courts in ways that even I have found quite surprising, and being an advocate for the Declaration. So we saw in Takamori there was references to the Declaration in relation to citing articles that refer to the importance of repatriation. And we saw some references in other cases around the Treaty of Waitangi, that you interpret the Treaty of Waitangi now with the gloss, I guess, of the Declaration. We've seen the Declaration support land rights and recognition of land rights in another case, and explicit references to the Declaration, and a real engagement also by lawyers acting on behalf of Māori to raise the Declaration, use it in support. And it's exceptional that these references come really from our highest court, so that's going to filter down, I would suspect. But the declaration has not been determinative, and that's probably right, given that it's a non-binding instrument, and that its value really is in interpretation. So the other point to make about this is that these decisions don't actually conform to the declaration. The declaration demands much more than our courts demand. So, yeah, that's it. So basically, I've just gone over the idea that centrally and inherently and basically the New Zealand legal system is very unitary. It's not federal. We don't have very much sharing of power. We've got a very strong parliament with a lot of power, and there's been very little acceptance that there can be any other legal system in place as a formal legal position. The situation on the ground is a lot more colourful and complex, and we increasingly see the courts engaging with tikanga, not in a highly successful way, but we do see tikanga coming into our mainstream courts in cases like Takamori, not winning, but you see that our courts can't avoid tikanga issues because that's just the legal landscape and the political and social and economic landscape in which we work in Aotearoa, New Zealand. Thank you.
Thank you very much, Claire. I hope you heard the applause. Thank you very much. We very much appreciate you taking the time and the effort of introducing us to the complexity of the New Zealand system. We now have to cope with the technical difficulties of keeping you also in the loop for discussion. Are you able to follow the videos in video streaming what is said here? Because yeah, okay, perfect.
Yes.
Okay, perfect.
But the only problem, I'm sorry, is that there's a delay with the streaming, so that's a bit later. So I'm going to try and stay on Skype if possible.
Okay, there's a delay. Okay, so in case you can text me via Skype, and I can maybe read your comments or something, or say some. We will see now. It has to develop. It's the first time that we do so, and I apologize for financial problems, but we will try to include you. So I will immediately give the floor to the public. I'm tempted to say something, but as we have had a lot of questions before, I hope this will be the case also now. And so, someone wants to deal with. There are a lot of things on both cases, and then we'll try to separate, maybe if possible. Let's see what the question. Roberto, please. Yeah.
Well, thank you very much to both speakers. Of course, I knew very little, and I know much more about the two systems. And so I would like to have an opinion by the two speakers, if possible. Are you familiar with interlegality, which is an approach which is different, let's say, from legal pluralism? Is it better now? Okay. So it seems to me that in the case of both countries, we have examples of how interlegality works or may work. In other words, we don't have that duality that we have been exposed to when we first heard Alexandra this morning. What shall I do? Yeah? But it seems to me that we have here an attempt of the same judicial institution trying to mediate, to accommodate two legal systems and decide on a case-by-case basis what would be fair, appropriate, and compatible, what would be a fair, sustainable, and compatible solution to that particular case. And I found the words used by Claire, if I quote correctly, judicial awareness of one culture judging another culture. So it seems to me that this judicial awareness is already a very important step, precisely because it would be very difficult to have a legislative solution which might be in the line of legal pluralism, which means completely indifference of the different cultures, of the different legal systems. Whereas at least here there is an attempt to find this kind of paradoxically common ground. So I would like to have your opinion on this. And two very small questions. First, in Australia, do you have only the Social Justice Commissioner, or do you have a network or a whole system of commissioners, as we have, we call them ombudsman in many European countries, and they are sectorial? And a second question, which is very naughty, I shouldn't make it, but I do make it. Whereas at least here there is an attempt to find this kind of in a pure academic spirit, and in line with what somebody is doing in Canada, applying law and economics to the field of plurilingualism. I think it might be interesting also, for the sake of information, to try to apply law and economics to the issue of indigenous rights, because it might measure the impact and the commitment by governments in the area of protection of indigenous rights. And that might be also something on which I would like to have Alexandra's opinion. Thank you.
Any more? Are there any more questions? Cheryl, please. I might add also, if you can add something on the Commission of the Human Rights, because in the presentation you were referring to us when I noted this down, what they say about us or something. So it sounded like if there were indigenous Aboriginal people in the Human Rights Commission, as far as I...
Yeah. Shall I?
Yeah, maybe Cheryl first, please.
Can I just make a sort of a very brief addition to something that Debbie said, a little bit prompted by Roberto's comment about judges in one, and who in turn was prompted by Claire, about judges in one culture trying to understand and accommodate cultural perspectives from another. I mean, Debbie made the point that there are very few Indigenous judges in Australia and have been over time, and she said that's can in turn be traced to the fact that there's very few Indigenous people in the legal profession. But equally it's true there's very few Indigenous students in the law schools. There has been over decades a significant attempt to try to increase the number of Indigenous students, and indeed there are some, but still quite a small number of Indigenous students going through. But when they get to the other end, they don't necessarily want to go into the profession. Many of them want to do things that are more active. So one of the most powerful Indigenous leaders in Australia, who's leading aspects of the constitutional reform movement that Debbie was referring to, is a highly skilled lawyer, but there's no way that he's going to go into the profession and up through the judiciary so as to be able to perform that role, because he thinks he can perform a more effective role for his people in some other way. So, I mean, there is a compound problem here that, at least in the short term, has to be dealt with in the way that that you were describing, I think, Roberto.
Okay, thank you. Are there other remarks? Then we can have a first answer. Debbie, would you?
Sure. Can I start by clarifying the Human Rights Commission position? So, under the federal legislation, we have a federal commissioner, an overall human rights commissioner, and then we have subject matter specific commissioners: sex discrimination, age discrimination, and the Aboriginal and Torres Strait Islander Social Justice Commissioner is generally an Indigenous person is appointed to that position, and that remit is specifically to look at Aboriginal and Torres Strait Islander issues. It's a critical policy role for Indigenous people, absolutely critical.
Okay, so he's practically the voice of, in a way, a voice of the Indigenous.
Well, it's the closest. It's the closest to an an official voice, I suppose. You know, like Cheryl was saying, there are very powerful Indigenous leaders around the country who operate completely independently of government. But what you don't have is an Indigenous voice within government. Very few Indigenous politicians, I think, a very strong contrast with New Zealand, which has much better political representation. So you don't have a voice at all in government, and that's one of the key complaints of Indigenous people. So this commissioner has a very important role, not quite inside government, but very close to government, and with a lot of policy agendas. So it's a very critical position.
Can I just follow up the question? So I was wondering, why do you think that there are not a lot of Indigenous law students? And why do you think that after they graduate, they don't want to practice law? And equally, why do you think in Australia, you were saying, I forgot the question, I'll come back. But again, in terms of resources, you know, I wanted to say why you don't think that Indigenous people wish to, maybe judges, you know, wish to go to these roles?
Well, I think it's an application of other diversity issues. You ask why, for example, we don't have better representation of women in these positions or other minorities. There are a lot of similarities. But remember, fundamentally, Indigenous people are only 3% of Australia's population. So that's the first point. Not numerically, you know, not strong. Secondly, the education issues. So if you take that 3% and then you ask what percentage of that 3% are even completing their school studies, let alone their tertiary studies, you know, the pool gets very, very small. And then you put on top of that issues about the conflicts a lot of Indigenous people feel between their obligations to their community, to often, particularly if they're not from the city, they have to leave their community to undergo their education. They have to stay away from their community if they want to pursue a profession. So not only in a personal sense, but in their obligation sense, they are pulled between all these things. And then they are entering a very conservative, anglicised institution that is unfriendly. It's unfriendly to all minorities. It's generally still pretty unfriendly to women even. You know, there are a lot of things, a lot of pressures. I've seen that with young Indigenous lawyers myself. You know, it's so foreign for them. So it's not welcoming. It's not understanding. There are a lot of cultural issues like that, I think, that are difficult. It's a very hard road for people to see it all the way through.
So my point was kind of like a question and also comment, just about the Commissioner being the only sort of representative body or whatnot for Indigenous people. And I guess it fits in a lot, Debbie, to what you were saying about the lack of framework structure and the lack of commitment at a political level to fund organisations that sort of help consultation and whatnot. And so there was ATSEC, and then that was dismantled, and then there was a Congress, you know, and Congress has just in the last 12 months had all its funding pulled out from it. So there have been in Australia, I think, attempts to have wider consultation and wider sort of leadership groups that encompass, you know, Mick Gooder is amazing, but can only sort of, you know, do so much with the plurality of Indigenous interests at play and whatnot. And I think that there have been in Australia structures to try and bring those plurality of interests to the fore, but there hasn't been a strong commitment from government funding and funding organisations to sort of stay with them and prop those kind of initiatives up.
Can I just pick up on something Claire said about the way that in New Zealand iwi use they use the land settlements to as an economic stimulus to develop their communities. And you see, in Australia, you would think that under native title settlements, sometimes that same economic driver could help. But most of the communities have to use the money they have for basic services, delivery of health, delivery of education, delivery of employment. And so in terms of capacity building and lobbying and policy reform, I mean, there's not enough funds to go around, even the funds that they might be able to generate from land settlements. The funding they need goes into those very basic services, and all the more sophisticated capacity building, there's just no funding for that if government doesn't provide it, and government is cutting it.
Yeah, Alex, just to, yeah? Okay.
You see, for me, the example of Australia and New Zealand, the examples are very interesting, and they're interesting on their own, but also as a comparison. And I wonder whether the issues, the distinction between the two also has to do with how Indigenous peoples are viewed, and this represents very much the situation elsewhere. So there is this tendency of Indigenous peoples being discussed as victims, which they are, but it also disempowers them. So this idea that, you know, they are the very poor, very vulnerable, and this is in contrast to what we have seen at the international level, where Indigenous have actually been very powerful and very strong and very committed and getting things done. And also there is this, also there's another rhetoric that unfortunately Australia has fallen into. I was talking earlier with Debbie about this, seeing Indigenous problems as social problems. So, you know, and I'm answering indirectly to what Roberta asked. So, you know, it has to do with economics, and it has to do with, as long as, you know, they're not discriminated against, that's all, you know, there is to it. As long as, you know, they get water and they get electricity, and that, okay, I oversimplify. And again, you know, this is, and actually Australia stood up at some stage in early, in late 90s and said that, you know, Indigenous people's problems have nothing to do with human rights. It is a social issue. So looking at them a bit like the Roma, you know, are looked on in Europe. And I think that, again, this is, and of course, you know, Debbie's right, these are, Debbie used the right tone, these are problems that they do have. But in a way, you know, we delegitimize their claims to separate systems by treating them either as as weak victims or as a social kind of problem. And I see this in Australia and elsewhere, and I don't necessarily, to the same degree, see this in New Zealand.
We have promised also to let Claire reply, but Marco, for technical reasons, it's better that we bundle the questions here a bit, and I hope that Claire will understand. Thank you very much. She hasn't much way to...
I will just to jump on this point made by Alexandra, because it could be also the other way around. By using the human rights language, you overshadow the social issue. By using the diversity narrative, the fact that you need legal pluralism, you most of the time tend to lose the fact that there are profound social issues behind these issues of redistribution, of social justice. So I completely accept the point, but I would like also to urge you to understand that there is also the flip side of the point you are making.
Okay, then we will give the floor again to Claire to reply. It will be very difficult, but I'm very confident that she will make it. I would like to add one question myself, which is on the language issues, because you were mentioning the concepts in this body snatching case and the difficulties taking into account the customary law, and while Debbie was expressly mentioning also language difficulties in understanding, especially the English common law terminology. So they are both sides. The judge, who has to know something to take into account, and also probably to know some indigenous terminology, but also the other side in a common law trial to understand, as it has been pointed out. So is this a problem in New Zealand too? Are there parallels, or is the situation radically different from that? And if both speakers could afterwards maybe add something also on what you stressed, and also Debbie in her presentation on the question of unitary versus federal system. This would be also nice if there would be some, because this would connect us also with the second panel of this afternoon. So, but now I stop because you have a lot to reply to. Thank you.
Thank you. I'm very sorry, but for a moment, just when the questions started, I missed some of the questions. I was trying to go into web streaming, but it was delayed and this microphone was off, so I missed some of the questions. I caught something at the about the judicial awareness point and the importance of judicial awareness. I think that's a function of the social setting, I guess, in Aotearoa, New Zealand, that it's very difficult not to have some awareness, even for judges, of Māori culture and also of at least some idea of some central principles to tikanga Māori. So that awareness is in this context, I guess, not overly surprising. It is a good thing, in the nuanced way that our courts now deal with tikanga, at least the language that they use is very respectful. Even if that doesn't translate into tikanga winning the cases or doesn't translate in tikanga being given a whole lot of legal teeth or recognition in the mainstream system. There was then a bit of a discussion that I heard about Indigenous students and particularly in the Australian setting. I would say that we have quotas at my law school at Auckland University and also at the previous law school that I worked at in Aotearoa, New Zealand, and Victoria University of Wellington, of 10% of our places are reserved for Māori students. We also have some reserved places also for Pacifica students. We have large Māori student bases and student populations, so we have, it is roughly 10% of our student body, so I guess we have up to sort of 200 or 300 Māori students at any given time, which is a fairly large body. It's very different from a Australian university. We have permanent people employed in place. We have Associate Dean Māori. We have all sorts of initiatives where we do teaching up on the marae. I also teach tikanga Māori to our Giurisprudenza course, which is a compulsory course for everybody. And we take people up to the university marae, which is the university sort of Māori meeting house. So that every student that goes to our law school has done at least 3 weeks of introduction to tikanga and has spent some time on a Māori meeting house. That's in addition to, I guess, quite a critical perspective that we do in a number of our other public law, land law cases on the treatment of Māori under the law. So it's quite a different setting, I think, from that in Australia. We still do have a problem with, however, with the number or insufficient, I think, Māori in higher positions in the legal community. So I mentioned before that we've only currently got 2 High Court judges. We've only had 3 in total, none at the higher levels who are Māori. Hopefully that will be changing. It's certainly, even in the 20 years since, or almost 20 years since I graduated from my undergraduate degree, there's been significant changes. There is a problem that we also have for our Māori students, that often they have obligations to their community, also, which can be quite onerous. If you have a law degree, you can be snaffled for different purposes, including claims against government in relation to historic treaty breaches. One thing that our Māori students do struggle with, there was some discussion about, how Māori find it. There is a systemic bias. I mean, in the system that they're learning, this relates to another question that was asked, that they're learning a legal system that is not Māori, and they're subject to a legal system that is not Māori. One point I wanted to make about representation, which is very different again from Australia, is that how Māori representation works, at least currently. So you have your seats that I mentioned in Parliament, which is important politically, but we have very powerful, so iwi leaders groups that have a very close in with the highest levels of government. They're a very strong force, particularly on issues around resource development. It's very hard for the government to go against what the iwi leaders group says. The government has to work very hard to keep our iwi is the name for tribes, really, tribes or nations. Hard for our government to go against what our iwi leaders groups state. That representation structures are changing and have changed in relation to treaty settlements, but generally Māori representation at the national level is pretty strong. It could always be stronger, and very rarely a Māori given veto, talking about free, prior, informed consent that Alex did earlier. So yeah, political power is strong. One thing I was really interested in that discussion that was just sort of developing around how kind of Māori rights or recognition of Māori or Indigenous peoples is based as a social issue, is it a human rights issue? What are the consequences of framing these issues or seeing these issues in different ways? It reminds me a bit of that very important work by Benedict Kingsbury around the different justifications for Indigenous people's rights, and depending on how you frame them or consider or see those rights or justifications for those rights means that you prioritise different sort of rights. What I've always found really interesting is a comparison between Australia and New Zealand is that Māori, I think, are very much recognised as a political grouping. They might not have self-determination. In fact, the structure might not allow for much pluralism, but they're certainly accepted as a powerful political force in different ways and as nations. Dealing with Māori issues is not about dealing with discrimination only that can come into it. It's not about dealing with just economic disparities or socio-economic problems, although Māori do face those issues. It's also about recognising that Māori are first and did have self-determination at least prior to assumption of control by the state or by the colonial government, and that really changes the way that we deal, or makes it quite different from I think the Australian way of dealing with Aboriginal issues, which is often dealt with as, it seems to me, I don't want to talk around Australia when there's people with so much more expertise than I have in relation to Australia, but often dealt with as sort of a discrimination issue, or at least from a legal perspective, or a land issue. I find it interesting. We teach all of our Māori favoured stuff really in public law. It's about public law, whereas in Australia it seems a lot of the Aboriginal issues come up in land law because it's about native title. So there's different ways of thinking about these things and justifications for these rights, and I think is interesting. There was a question about language issues. Te Reo Māori is a national language. We've got two national languages, English and Te Reo Māori. You can do all public documents and also bring cases in the Te Reo Māori, and that has to be accommodated with translation services, etc. One thing that is quite different again with Māori compared to Aboriginal communities generally is that Māori, we're a lot smaller space. You don't have very remote areas where Māori are divorced from the sort of the rest of the community. Māori are quite au fait with at least English legal systems. English is spoken by all, even if Te Reo Māori is also spoken. So that's not to say that the system in the English legal system is not foreign to Māori who are particularly. While we're not in remote communities, there are certainly communities where tikanga Māori basically prevails in fact. So there is that problem there in terms of sort of language difficulties or barriers. There was you mentioned at the end a question in relation to Debbie's paper around unitary and federal states. I'm sorry, I didn't hear the comments around that, but they did sound very interesting, and I would love to comment on them, but I didn't quite hear what the point was, or I didn't hear that comment around the unitary versus federal system, so I can't respond to that. I didn't hear it. Thank you.
Yeah, I might just say something about that.
Thank you very much, Claire. I think this was all very clear and all very helpful. And now Debbie has been provoked also probably by the remarks on the comparative remarks on Australia. And I think this is a nice dialectics. And if you would please reply, and maybe also to the last point.
Okay, I might start with that point about unitary and federal, because I think it's a very important both structural and practical difference. The approach to Indigenous issues in Australia is terribly inconsistent and divided because it's a federal system, and because legislative responsibility for some issues lies with the states and sometimes lies federally. So you have great disparities in approach. You know, you overlay with that not only the legislative power issues but the political issues. You have concentrations of more traditional Aboriginal communities in some states than you have in others. That leads to political and legal differences in approach. So the whole system is really lacking in a lot of coherence. And that's why, you know, when Mick Gooder, the Social Justice Commissioner, calls for a national strategy based on the Declaration, one of the things I think he's trying to highlight is that we have to overcome that the consequences of federalism in that way and try and rationalise things a lot more, because that is just it is a significant impediment to any real improvement, I think. Can I just pick up generally on what Claire has said about some of the differences between Australia and New Zealand, because I think they are, and I'm speaking here as a New Zealander, so it's a difficult perspective I have. I have been struck all the time I've been living in Australia about the differences, which I think go right back to very basic attitudes and very basic differences, if I might say so, along racial lines. There's no comfortable way to put that, I think. And I think it's something that Australians have to face up to, and they don't face up to it enough. And there's a lot that we can learn from the New Zealand approach, and I notice that some of our Indigenous leaders are using that a lot more in their public statements than they used to. New Zealand is being held up as a close and familiar neighbour who is doing a lot better with their Indigenous issues than Australia, and I think that comparison is becoming more forthright, and it's a very interesting one. It'll be interesting to see what the political reaction to that is. I think it's a worthwhile development. So
thank you very much. I think this was extremely interesting. It was, of course, only a kind of appetizer for what we will probably elaborate much more in the book, but I think especially also the last comparative dialectics between the both of you was very, very interesting, and thank you for sharing sharing this with us, which will also, in a way, bridge to the second session of today, of this afternoon. I have a number of questions here, but the technical thing here is too difficult for me to work this all out, and we are all hungry here. You have to go to bed probably, or it's very late. Yeah. No, but it's... Okay, thank the both of you and all the other presenters and discussants of this morning sessions. Thank you for staying with us. We will now go for lunch here, and we will meet back at 2:45. Well,
we have another Skype connection.
Yeah. Yeah. But I think 2:45 is... But 2:45 sharp this time, not like the UN declaration, but...
Oh.
Okay. So thank you, and bon plan. Thank you. Thank you very much. Thank you very much, Claire.
Thank you. Bye-bye.
Bye-bye.